Hi everyone, my name is Qaisar Mahmood. I'm one of the HR consultants here at THSP. My talk is likely to last about 10 minutes approximately, and the purpose of today's talk is to give you a background into the Employment Rights Bill, highlight to you what areas are likely to change within the Employment Rights Bill, and focus on some of the key areas that are likely to affect all types of businesses. And lastly, where is the Employment Rights Bill currently at, and what are the timescales? So, just some background. The Employment Rights Bill has come as part of one of the 5 mission-led priorities from the Labour government in 2024. This was to grow the economy and to ensure that as part of their plan to make work pay, this would work for employees. It was introduced to the House of Commons on the 10th of October 2024. The government is geared towards making work pay by ensuring that there are better systems and fairness in employment, ensuring that people are treated in a fair and transparent way, encouraging employment and productivity. The aim is to ensure that people can rely on day one rights and that they are supported, sending a message of incentivizing that you are better off financially by working than not and claiming benefits. I would like to add that this reform encompasses 28 key areas aimed at enhancing worker protection and modernising the current employment law model in the UK. For those who attended the last Employment Bill update, which was on the 29th of May, I concentrate on the following 5 areas. A day one right on unfair dismissal. This is a day one right for all staff members to be able to make an application to an employment tribunal for unfair dismissal, which currently requires a 2-year service period with the employer. Statutory sick pay. Currently, you can claim statutory sick pay from day 4, as there are 3 waiting days currently. With the new Employment Rights Bill, an employee can claim statutory sick pay, which is known as SSP. It will become payable from day 1 of sickness. Thirdly, to end exploitative 0-hour contracts and introducing a minimum guaranteed hours. This will be calculated over a 12-week reference period. There will also be reasonable notice that will need to be given for any shifts that are either changed or cancelled at short notice, including compensation. To have a day one right for family and parental leave, including parental leave, unpaid parental leave, and unpaid bereavement leave. Currently, for these types of leave, service is required with the employer. And lastly, I covered off to strengthen the existing day one right for flexible working, introducing employers to explicitly right to explain why the refusal is reasonable. Today, I'm going to be covering off another 5 areas which have been incorporated into the Employment Rights Bill. The first one is duty to prevent sexual harassment. The aim is to strengthen the duty on employers to take all, and this is in quotations, all reasonable steps to prevent sexual harassment. This includes well-documented policies and processes, plus any relevant risk assessments and action plans. Currently, the government has opened a call for evidence on what actually works, and this will close on 30th of June. I'm sure people are aware about a call for evidence. These are used to gather information and insights on a particular topic, often before a policy decision or a law is changed, where both individuals and businesses can contribute to this. Harassment of third parties. The bill will also incorporate an extended duty on employers not to permit harassment of their employees by third parties. The employer will need to demonstrate that it took all reasonable steps. Again, the word all has been included, again in quotations. All reasonable steps to prevent this. Harassment will also be based on all protected characteristics and not only sexual harassment. Advice for employers is to review and update existing policies, refresh, conduct further or new risk assessments, set up clear reporting channels and define responsibilities, mandate regular scenario-based training, including recording attendance and evaluate its impact, and third-party conduct to be mentioned in policies, signage, as well as codes of conduct. The next thing I'm going to be talking about is the employment tribunals. Currently, the claim time for both unfair dismissal and discrimination claims is 3 months minus 1 day from the date of the dismissal or the last act. The proposal here is to increase the claim time for unfair dismissal and discrimination claims to 6 months. The fourth one is Fair Work Agency. It's known as the FWA, so Fair Work Agency. The government wishes to establish the FWA, which is known as the Fair Work Agency, who will be able to take action against labour abuse, enforcing worker rights. The aim is to simply check compliance and to provide clear guidelines on meeting standards, including sick pay, holiday pay, etc. The FWA will replace several enforcement bodies. These include those overseeing minimum wage, statutory sick pay, holiday pay, and labour exploitation. This will create a single hub for enforcement. FWA officers can enter business premises and they can seize documents and digital records, and they can ask and request information. They can also request undertakings from employers and escalate non-compliance to criminal fines. The next thing I will be talking about as part of the Employment Rights Bill is the protection from other dismissals for those on maternity leave. The bill will also introduce regulations to cover other dismissals. These will include during pregnancy, maternity leave, and following a return to work. The bill will also apply to adoption leave, shared parental leave, neonatal care leave, and bereaved partners' paternity leave. The bill proposes making it unlawful to dismiss such employees during a protected period. This protected period is likely to be 6 months after their return from these types of leave. So where are we in the process of this becoming law? The bill is currently in the House of Lords. Lisa, could you show the diagram? The diagram is not being shown, so I will read the diagram out to you. So this started on the 10th of October 2024. The bill started in the House of Commons. It's had its first reading, second reading, the committee stage, report stage, and third reading. So the House of Commons part has been finished. Currently, the bill is in the House of Lords. The first and the second reading have both been completed. First reading was completed on the 14th of March, and the second reading was completed on the 27th of March. Currently, the bill is in the House of Lords at the committee stage. It's been at the committee stage since 29th of April, 2025. After the committee stage, this will move on to the report stage, which is number 4, and the third reading stage within the House of Lords. Once this stage is finished and the bill has been finished its business in the House of Lords, it will move on to Royal Assent. This is expected in July 2025. The first point is consideration of any amendments, and after that first point has been completed, then it's Royal Assent. Some laws are expected to come in shortly afterwards. However, the general understanding is that the employment bill will not come into effect until around autumn 2026. So what are the 3 key takeaways from today? The Employment Rights Bill is likely to come into effect in autumn 2026. Some of the more straightforward changes may come in earlier, i.e. SSP, which is statutory sick pay, and that will be paid from day 1 of sickness. Businesses should also start to think about the likely impact this will have on their business stroke operations, thinking about which policies or codes will require updating, and how will you as a business show that you have conducted appropriate risk assessments to ensure that your staff are safe from all types of harassment. Please feel free to join us in the next employment bill update here at THSP. Dates and times will be posted in the usual way. Thanks for listening. I'm open to any questions. I don't think there's any questions. If anyone has any question, they can still contact me directly, or they can use the employment law email to contact anyone of the HR consultants at the employment law email. Thank you for listening. Goodbye.